Hi, I'm Tom Pollard.
And I'm Malaya English.
And we're volunteers with the Habeas Corpus project.
The Habeas Corpus project is a legal charity that provides free legal assistance to immigration detainees.
We will be bringing you bi-weekly news and case analysis of immigration detention matters, and this is the second episode of that podcast.
To donate to the Habeas Corpus project, please press the link below.
This week, in immigration news, Her Majesty's Prison Inspectorate report has found that at Channel facilities, many migrants were forced to sleep in a disused freight container. Many slept on the concrete floors, and many had no food, drink or clothing. There were serious safeguarding issues as well, with women and children forced to live in the same room as unrelated men. Excessive child detention was also present, with one child held for 58 hours. Many of the detainees had not eaten, were dehydrated, and many even pointed at their mouths to indicate their hunger, unable to speak or speak the same language as the officers who were overseeing them. The report also found that scabies, headaches, diarrhea, and other maladies were present in the location, and the inadequate toilets only exacerbated these health risks. The report puts this all down to what it calls a lack of urgency about moving detainees along, and there were no adequate sleeping facilities either, with nearly a quarter held for 24 hours and one person held for 3 days. Over 3,500 people have been held over the summer months, 370 of them children without accompanying adults. Many are from Eritrea, Sudan and Syria. Now, this has obviously been a huge mismanagement by the Home Office, and it has been admitted that many of the staff did not have the required training. Immigration Minister James Brockenshire has admitted that the freight shed was used and said that it will not happen again. Peter Clark, Chief Inspector of Prisons, called this unacceptable.
For our second point of news, a report published by Prison Watchdog on the 1st of March revealed that the UK's largest immigration detention centre, Harmondsworth, which holds up to 661 men, is holding migrants in detention without a time limit for administrative purpose in conditions which were found by inspectors to be unacceptable. The Chief Inspector of Prisons found that some men were held at Harmondsworth for an unreasonably long time, including 18 men who were held for more than a year, and one man who was held on separate occasions, but for a total of 5 years. In regards to the living conditions at the centre, the report stated that the centre was desolate with bare rooms, broken equipment, and infested with bedbugs and cockroaches. Additionally, it was dirty and overcrowded, and poorly ventilated with unsanitary toilets and showers. Some detainees who were also segregated for too long, and detainees who had been recommended for release by an independent panel or by doctors for their mental health, continued to be held at the centre.
Thirdly, and in slightly more uplifting news, the House of Lords peers have voted to allow asylum seekers the right to work if their claims are not processed within 6 weeks. Additionally, they have voted to allow overseas domestic workers to change employers without the risk of deportation, and the right to remain for 2 years after doing so. This is to avoid abusive situations in the workplace. Despite the fact that the government itself was against this amendment, it was supported by 226 votes to 198 in the House of Lords.
For our fourth point of news, from the 6th of April, all skilled workers from outside the European Union who are earning less than £35,000 a year and have lived in the UK for less than 10 years will be deported. Some jobs, such as nurses, are exempt.
Our fifth point of news this week, France has asked the UK border guards to make weekly tours to Calais refugee camp in order to inform people there that Britain will make it harder for asylum seekers to enter the UK in future, and also that it will make it more difficult for asylum seekers to make a stable life in this country. This is part of a drive by both governments to effect a total closure of the camp, after part of it was recently demolished last month amid violence and protests. Xavier Bertrand, president of Nord-Pas-de-Calais, predicts that the Calais camp will soon shut down with the coming immigration bill from the UK government. This bill promises to tighten restrictions on landlords who may give housing to migrants, and also on people who may give them gainful employment. The bill will furthermore restrict asylum seekers' right to work in the UK in general.
For several years now, Australia has effectively outsourced its asylum seeker problem, paying hundreds of millions of dollars to Nauru and Papua New Guinea to house offshore detention centres. In a decision announced in Canberra last Wednesday, the court found that the Commonwealth conduct was authorised by law and by Section 61 of the Constitution. A majority of the full bench found that Section 198 AHA of the Migration Act, which was passed by the government in June last year, allow the Commonwealth participation in the plaintiff's detention in a foreign country. This is a significant victory for Australia's Conservative government and its tough stance against asylum seekers. Human rights groups say the ruling will mean that 200 asylum seekers who went to Australia to seek medical treatment, including 37 babies who were born in Australia and 50 children, will be forced to leave Australia and be moved to Nauru. About 500 migrants are currently living in the detention centre, 3,000 kilometres northeast of Australia. Speaking in Parliament after the ruling, Prime Minister Malcolm Turnbull defended the controversial border security arrangements, saying they were necessary to deter and prevent people smuggling. However, UNICEF said that it was unreasonable for Australia to shift responsibility to developing country. Additionally, legal experts say the recent decision to return to the offshore processing of refugees is a violation of the international conventions and treaties to which Australia is a signatory, including the United Nations Refugee Convention. Australia intercepts all boats bringing suspected asylum seekers to its territories and takes those on board to such islands. Even if they are found to be genuine refugees, they will not be granted asylum in Australia. The government says the policy deters people smuggling and saves lives at sea, but it has been widely criticised as breaking Australia's legal obligations.
Thank you very much.
Thank you.
Hello, my name's Freddie Russell and I'm a caseworker here at the Habeas Corpus project.
And my name's Anna Ashford and I'm also a caseworker here.
So in this section we're going to be discussing the Immigration Act 2016. This received royal assent on the 12th of May, 8 months after its first reading in the House of Commons. So we're going to look specifically at what the Act lays out in terms of immigration detention and why it took so long before it gained royal assent. So Anna, what did the initial reading in the House of Commons propose in relation to immigration detention?
Well, initially the House of Commons proposed very limited changes to immigration detention, ignoring all ideas of either increasing judicial oversight or introducing a time limit on detention to address the issue. Rather, their initial changes focused on ending the use of temporary admission, whereby a detainee requests the Home Office directly for release, and providing instead an overarching framework for immigration bail.
And then there was a lot of further discussion. Why did that occur and what did it mean for immigration detention? What were the amendments?
Well, in the past couple of years, immigration detention has come under increased scrutiny. We have seen very critical reports, both from an all-parliamentary group on migration and from the Prison Ombudsman Shaw. He wrote a report which was commissioned directly by the Home Secretary herself. Moreover, campaigning groups and the general public have become increasingly vocal about the state of immigration detention. However, despite this, the initial bill from the House of Commons proposed very limited changes, as I said, to detention. And when it was read in the House of Lords, they sent it back to the House of Commons with multiple amendments. Lords Ramsbotham proposed an amendment to the bill to introduce a statutory time limit to UK immigration detention, which was agreed to be at 28 days and added as Amendment 84. Some members argued that the time limit would put undue pressure on the judiciary, Lord Keane arguing it would significantly impact our abilities to enforce immigration detention and maintain public safety. However, Lord Rosser countered that in a country where we uphold justice and the right to liberty, that at least after a period of time, the decision to continue to detain has to be a judicial one, not an administrative one. In the end, the Lords voted in favour of this amendment, 187 to 170. They also voted in amendments to increase judicial oversight in detention and Amendment 85 to cease the detention of a pregnant woman.
And what does the Habeas Corpus project think of these amendments?
Well, we at the HCP strongly encourage judicial oversight and access to justice. If passed, Amendment 84 would end the UK's practice of detaining people indefinitely and reflect the growing time for a time limit campaign. Requiring the permission of an immigration judge to continue detention beyond 28 days would bring the rule of law into the decision to detain. This amendment would hopefully reduce the number of people being unlawfully held in immigration detention. Furthermore, ending detention of pregnant women would be an improvement in safeguarding vulnerable people from unsuitable conditions.
So how did the House of Commons respond to these amendments?
Well, we saw the first ping pong as the bill was sent back to the House of Commons on the 25th of April 2016, where MPs voted to disagree with Amendments 84 and 85, with 302 ayes and 266 noes. Rather, they amended that there was a duty to arrange consideration of bail after 6 months of detention and place a time limit of 72 hours on detaining pregnant women.
And so what was the culmination of this ping-pong match between the two houses?
Well, on the 26th of April, it went back to the Lords and they rejected the House of Commons' new proposal and insisted upon their amendment to introduce a time limit and increase judicial oversight in detention. They, however, agreed with the new proposal for Amendment 85, such that pregnant women could not be detained for longer than 72 hours. The Commons then debated again on the 9th of May and ended the stalemate between the two houses, but without placing a time limit on detention. 2 new reforms were, however, agreed to. The first is that an automatic bail hearing will be scheduled for detainees after 4 months in detention, in response to the Lords' demand for greater judicial oversight. And the second is that there will be a 72-hour time limit on the detention of pregnant women, although this can be extended to 7 days if authorised personally by a Minister of the Crown. We strongly feel that the reforms have been stripped of all of their significance.
And can you qualify why the Habeas Corpus project thinks this? Firstly, regarding Amendment 84, the automatic bail hearing after 4 months of detention.
Well, an automatic bail hearing after 4 months is totally meaningless, as people were already entitled to apply for bail as soon as they entered detention. Furthermore, 4 months is too long to be deprived of liberty before automatic judicial oversight. Paragraph 19 of the bail guidance for judges presiding over immigration and asylum hearings describes 3 months alone as a substantial amount of time to spend in detention. Also, this automatic bail hearing will not apply to detainees with a history of criminal offending, who make a large proportion of the population in immigration detention. This automatic bail hearing is certainly not an extension of detainees' rights, and unfortunately there will remain far too little judicial oversight far too late on in a person's detention.
And what about Amendment 85, that is the 72-hour time limit for pregnant women?
Well, the 72-hour time limit for detaining pregnant women is a step in the right direction, but we would be far more satisfied with the Lord's original amendment of banning detention for pregnant women altogether. Our position is that detention centres are extremely unhealthy and unsafe places, especially for vulnerable people.
Well, thank you very much, Anna. That's all very interesting. Like I said, the bill received royal assent on the 12th of May, but it seems that what was a promising development in the campaign to improve immigration detention has unfortunately been rendered toothless.